Hello. The Divine Code reading for December 21st, pages 393 and 394. We are in the chapter Details and Examples of the Prohibition of Murder, the subchapter Causing Mortal Injury and Partners in Murder. We're in the third section of the subchapter. That's the third topic of the subchapter on partners in murder. That's topic 22 of the main chapter. The same rule applies. In yesterday's reading, we're learning about responsibility if two or if more than two people are involved in together committing a murder, doing an action that causes the person to die. And when they're who's responsible, when they're responsible, who's not or who's not held liable in a court of law. Basically, if two people work together and both are necessary to do the act of murder, and two people are working together, then they're both considered liable in a court of law. If more than two, if three or four people are, then they would not be considered liable in a court of law. They might be under the laws of Denham. The court might decide to create rules that they're liable, but in the Torah law, they would not be liable. And if one person could have done it by himself, he didn't actually need, but the other person decides to join in, the second person is considered an accessory to the murder, and the first person is considered the full murderer. So the same rule concerning partners in murder apply to two people who together perform one action that causes a victim to die, even if only indirectly, as explained in topic chapter 1, topic 2 above. In chapter 1, topic 2 was discussing indirect murder, and that's like if a person ties up someone in front of an animal so the person cannot get away, and the animal kills the person, and that was the intention of tying the person up, then the person that tied the person up would be considered murder. So if two people tied up someone, that would also be considered murder. Both are liable to capital punishment for this in a court of law, with the limitations explained in topic 21. So that's if it's two, again, with the exceptions being like if one person would have done the murder all by himself, the other person couldn't have, and therefore the one person that could have done it by himself is the murderer, the other person is not, is an accessory. Or if a larger group of people were involved, they're all considered accessories, but they're not. No individual would be considered a murderer. Only if there's one person or two people involved would the individuals be considered murderers. Topic 23. All that has been mentioned above in topics 20 through 22 applies only when the power and the effect of each person of the shared act of murder is clearly known. However, if 10 people struck one person and it is unclear which of them caused the actual death, or if attackers pushed a victim into a pit or a furnace and it is unclear which had the force sufficient to kill him, and which ones only assisted without contributing to the lethal effect, then all the attackers involved are exempt from receiving the death penalty from a court of law. And that's Tractate Sanhedrin 80a. It is clear that the same rule of exemption because of doubt applies to Gentiles. because it's for the Jewish court, it would be Sanhedrin ADA is referring to a Jewish court. In a case of doubt, they do not execute a person for murder in a case of doubt, and that would also apply to Gentiles in this case. And what they're talking about is a mob situation. You got a mob of people, and apparently there's those few people in the front of the mob that are attacking someone, and everyone else is cheering them on, and maybe they're trying to throw a kick in if they can get away with it, if they can get close enough. Everybody enjoys, they're all involved in it, but it's not clear who's actually doing. You round up the mob, the police round up the mob, they bring them in, and they don't know for sure who was doing the actual attack and who was just part of the mob that was acting crazy. In that case, they would not try everybody in the mob for murder. However, that's according to the Torah law. However, the court, for the sake of having a civilized, a proper society, the world is to be settled, the court may impose their own rules in such a case, and different societies will choose based upon what they feel is best for their society in such a case. But the Torah does not mandate liability in a mob case. Topic number 24. One who intends to kill one particular person and kills another person instead, or one who throws a stone at a group of people and kills one of them without targeting a particular victim, is considered a murderer. See, Rambam, the Laws of Murderers, 4:1, that in this case, a Jew would be exempt from capital punishment, since his judgment is based on the details of Deuteronomy 19:11, which specifies lying in wait for him. See Keshev Mishnah based on Tractate Sanhedrin 79. But this is not said regarding Gentiles. So in the Jewish court, if a person just throws a stone, and in this case he's doing it, he knows he's going to wind up killing somebody, or he knows there's a strong possibility someone's going to get killed. He just throws a stone into the crowd, and his intention is toward the strong possibility of killing someone. That would, regardless of whoever he killed, that would be considered murder for a Gentile. In a Jewish court, the randomness involved, there's exceptions, but those exceptions would not apply in a non-Jewish court, in a no-hide court. As explained in Min Kinuk, Commandment 34, topic number 8, it is also implied by Rambam, Laws of Murderers 6:10, that a Jewish murderer who intended to kill one person but instead killed another is considered close to having murdered willfully and cannot receive protection in the city of refuge. So whether or not he would be in an in-between state. For a Jew, that would be considered an in-between state. He cannot run to a city of refuge. Therefore, he is open to attack by a relative blood redeemer, a relative of the victim blood redeemer. Could attack him, could attack the Jew. So it's still considered in the very close to murder category. For a non-Jew, a no-hide court, that in-between state would not be there for this person. The person in a non-Jewish court would be tried for murder, even if he tried to kill one person and the stone or the shot missed and hit some bystander. That would be considered murder. In such cases of an unintentional murder that is close to being willful, a Gentile is liable for capital punishment by the court, as explained below in Chapter 5. And in Chapter 5, we'll be discussing, in the Divine Code, we'll be discussing the laws of the blood redeemer and that. So it'll show, in the area of uncertainty, we'll go into more detail in Chapter 5. Likewise, if two Gentiles threw stones or shot at a group of people and killed some of them, but it is unclear which person killed which victim, both are liable as murderers since they have each killed a person. It is clear that regarding the Noahide Code, it is not necessary to know which victim the murderer killed, as long as it is known that he murdered. So the way that this is written, it seems that, there are two people and each person shot one bullet into a crowd, or they threw one stone into a crowd. And each stone that went in, or each bullet that went in, killed somebody. Then it's clear that each person killed someone. It's not clear in this if the both of them strafed the crowd with bullets, and each one of them shot 10 bullets into a crowd each. 5 people died. And they can't tell which bullets did what. Would they still be both considered murderers? That's unclear in the halakha here. Also, if there's more than 2 people, so you have the partners, does the partnership issue of there being more than 2 people, is this an issue of partnership of the group, in which case both of them would still be liable, or maybe they wouldn't be because one person could have killed all 5, or is it a partnership deal at this point, so that if 3 or more people were doing the attacking, it would be under the threshold. That needs to be discussed more in this topic. It needs expansion. Topic number 25. Although a person has committed an action for which he is liable for capital punishment, it is forbidden for any other person to kill him. Only a court has jurisdiction to judge and punish the transgressor for his actions. One who does kill a transgressor other than a murderer stands before he stands trial, is himself judged as a murderer. Okay, so technically, it's a long footnote here, but okay, so that sees a crime, and he goes up to the perpetrator of the crime for a violation, and says the person is in Torah violation. If the witness kills the person, then the witness himself would be considered a murderer, except in the case of murder, but he still should not do it in the case of murder. So, we're going to the footnote here. See Sefer HaChinuk Commandment 204 regarding a Jew. The Minhag Chinuch, that's the exclamations of the Sefer HaChinuk, explains that it is clear that this does not apply within Torah law to a Gentile who witnessed another Gentile committing a capital sin. Since the Gentile can receive the death penalty based on one witness and one judge, and since the Gentile witness can become a judge in the case, a Gentile who sees a capital sin committed by another Gentile can also be the judge and mete out capital punishment based on the ruling he makes. Minkad Kinuk also writes in Commandment 4:10 that a Gentile who kills another Gentile who serves as an idol or willingly transgresses one of the other 7 Noahide commandments is exempt, for he has killed one deserving of death. The above reasoning is also mentioned here. Okay, so theoretically, if someone sees a violation occurring, that person could theoretically act as judge and executioner for that action. Theoretically. However, to the author, that's the author of the Divine Code, it seems unlikely that a person is actually allowed to proceed right away to execute the transgressor without first having the testimony accepted in a proper court proceeding. And this is where it gets into what the question of what is a proper court proceeding. Can it just be done? We would think of the Shimon and Levi. In the absence of a proper court system, Shimon and Levi executed judgment on a city. The city did not have a proper court system set up, and something happened that they had no way to fix through the court system, and therefore they acted as judge and executioner over the city. And the argument is that it was proper for them to do that. They had permission to do that in that situation. And if we're talking about like a Wild West scenario, which never actually existed, but if let's say we're out there in a lawless anarchistic society, it would be possible in that situation to do this. However, we live in a society everywhere in the world, for the most part, 98% of the world lives in places that have a functioning court system. Whether the functioning court system works or not is beside the point. But we live in a land, we live in places that have courts, and that's where we're supposed to go. And a Noahide, if we have a Noahide system set up, we would go to the Noahide system. Or if we have a reason, 98% of the world has a functioning court system, we would go to the court system in these cases. In general, no, I'm sorry. The footnote continues. Rabbi Zalman Nehemiah Goldberg notes that this appears to also be the reasoning of Tosafot Avodah Zarah 64b. Also, not everyone is qualified to be a judge or a witness in a court proceeding. So it is clear that the permission for a Gentile witness to become a judge in such a case is only for one who thoroughly knows the details of the Noahide Code and the Torah law process of administering the justice. And I would suggest that just as the Jewish courts, we have rabbis who are very knowledgeable of the law. They do not execute justice. They handle civil disputes. And although they would be qualified because of they're in a nation that has their own court system, they have to work through the court system the nation has. They have to accept that. And also, even if we have Noahides today, and I'm not aware of any, but if we had Noahides today who were on a level qualified to do this, if they're in a nation that does not recognize their authority, should not act on it, because they're just going to get in trouble. And there has to be a recognition of the local government in these matters. So definitely, um, yeah, today we would not, we don't have qualified people, and we don't have permission. We don't have the governmental permission to do this. Therefore, it would not be done today. Although the injunction, the murderer shall not die until he stands in the court to be judged, that's Numbers 35:12, is said regarding Jews, it is still logically incumbent upon Gentiles. For otherwise, everyone would take the law into their own hands, and there would be no standards of objective laws in the world. So, without a court system, everyone would be doing whatever they saw fit, and that really doesn't function well. It doesn't lend itself to a settled world, to have everyone figuring out the law themselves and executing each other. It just doesn't work properly. Therefore, we do not have permission to our ourselves mete out justice, to be a judge and executioner for things that we see. It has to go through a proper proceeding. Thank you.